My lord and my lords and my lady, the reason I'm standing is that there is a small pile of 4 cases in front of you.
4?
Half of them are me.
1,148 pages wasn't sufficient wherever it is.
Well, I'm sorry. The reason, the 3 of them are there for one reason, which is what prompted me, and that's why I've stood up. 3 of them, which is Hakimi.
Hold on. Hakimi, yes, yep. Got it.
AW. And
W, yes.
And SH Iran.
Yes.
Are there because they deal with the legacy process and the family process, and they set out what those processes were. And
right.
I'll just come back just to make a couple of points about that. Not much, but partly because we say this is ultimately for the first tier tribunal. Harrison is there for a different purpose. That's my learned friend helpfully has provided that. It is. It confirms. You may remember yesterday I made the point about citizenship being an area where the court, even on a judicial review, decides for itself whether someone is a citizen.
Yes.
Harrison is the authority for that, and it's at para 32. I'm glad my memory was correct. Basically, it's the top of para 32.
Right. Okay.
Thank you.
Thank you. Yes.
Good morning, my lords, my lady. I was about to embark on dealing with the appellant's grounds of appeal, so I'll begin with that, if I may.
Yes.
We say that the first tier tribunal erred in law for a number of reasons, and the upper tribunal was right to set its decision aside. And I've already made the fundamental point that this isn't about criticising the first tier. It's a question about whether it made an error of law. And I've already referred to the Tribunal's Courts and Enforcement Act 2007, which again, for the court's note, is at page 1040 of the Authorities Bundle. And we say in this case, this is a simple question, whether it correctly directed itself and asked itself the right legal question. And if it didn't do that, the fact that the Secretary of State's representative didn't help it cannot convert its wrong decision into a right one. We say that it got it wrong is clear from the submissions I made yesterday, but what I'll do is address 2 discrete points, if I may, just to draw the strands together. So could I start first with the decision of the first tier, which is in the core bundle at page 50. And in particular the findings and conclusions section, which begins at paragraph 20 on page 53.
Yes.
The court has already seen these passages, so I can be brief. What we say in a nutshell is that the focus of paragraphs 21 and 22 is on the question of whether fraud was material to the grant of ILR, and that is not the statutory question. And we make a secondary point, which is that it does treat Sleeman as determinative. And it was wrong to do that. Just then, in terms of the chronology, could I ask the court to turn back to the Secretary of State's grounds of appeal, which in our submission make the Secretary of State's position very clear. You were taken yesterday to an isolated passage, but in fact, the core of it is on page 45, in a passage which begins under the second hole punch. It is therefore submitted that character and conduct, along with the fraud, were expressly an issue in this appeal. The Secretary of State argued that had she known the truth at the material time of A's applications, they would have fallen for refusal. And then, although perhaps not in the way that a lawyer would draft them, those grounds go on to set out exactly what the Secretary of State says is wrong with the upper tribunal's the first tier tribunal's decision. And those include, first, on page 46, that the first tier tribunal has misunderstood and misapplied Sleeman. Second, grant of citizenship, page 47, top hole punch, which expressly points out that there was a failure to tell the truth in relation to good character, and therefore the Secretary of State was unaware of the appellant's fraud and couldn't correctly apply her policy to the facts as they existed in the real world at that time. And then third, grant of ILR. There's an express reference there to fraud not being irrelevant to the legacy programme, and the case of Hakimi, which is the case referred to in Matusha.
Yes.
And those grounds of appeal come 6 days after promulgation of the first tier tribunal's decision. So we accept that the Secretary of State's performance in front of the first tier tribunal was not acceptable, and that's regrettable. But certainly the position was set out very promptly thereafter. And then could I ask the court to turn to page 34, which is the upper tribunal's decision.
Yes.
And in particular, page 37, paragraph 12, we say that's the core of the upper tribunal's reasoning. It says, the first tier tribunal have made a material error of law owing to a failure to consider the false statements made by the appellant in his citizenship application. And rather than repeat points that I've made in writing and which will be clear from what I've said elsewhere, could I just direct your lordships and your ladyship to paragraph 41 and paragraph 44 to 46 of our skeleton argument. Essentially what we say there is that the upper tribunal was right to say that the first tier tribunal erred because it didn't ask itself the statutory question. That's what we say in paragraph 41 of our skeleton argument, although in somewhat longer form. And then at paragraphs 44 to 46, we make the point that the fact that a party doesn't assist the court does not mean that that court doesn't err in law. We've made the point in the skeleton that parties are entitled to withdraw concessions, that they're entitled to make completely new points. That's Miscavige. If it's right that a court or a tribunal doesn't make an error of law because of what a party has done, then one can imagine that all sorts of appeals, one will be trawling through submissions to see what the submission said and so on, and that's not the right approach. And it's a point my Lord Justice Dingemans made yesterday in argument. So that's our point in a nutshell. The first tier tribunal clearly erred in law, and that really is the beginning and the end of it. Just to finish on this point then, could I ask the court to turn up Sleeman, which is at Authorities Bundle 17. I'm mindful that the court has already seen it, but just for completeness I want to take the court to some additional passages. So, tab 17, page 510, paragraph 7, what the court will see is that there was an important point in Sleeman about the file notes, that the Home Office's file notes. And this court has been shown the file notes in this case. So paragraph 7, the case was adjourned to allow for the appellant's representative to amend the grounds of appeal to include reliance on a Home Office file note. that referred to the appellant having given 2 dates of birth, but stating that his age was irrelevant to the grant of ILR. So at the very least, in this case, at the point of the grant of ILR, the Secretary of State was aware that there were 2 dates of birth.
Is one to infer that there was no consideration by the Secretary of State of character in that one?
In this case, yes, certainly the Secretary of State was aware. There is further reference to the file note. So at paragraph 28 and 31, it's the submissions being made by the appellant's counsel.
Yes.
And then at paragraph 42, there's the decision letter. And it's right to say, and I'm mindful the court is already aware of this, in this case there was no reference to good character, of course, in the Secretary of State's decision letter, which is the point that was made yesterday.
Well, and the other point is, as you said, that the fact that 2 dates of birth had been given was known at least by the grant of ILR.
Yes.
So if it wasn't relevant to good character then, it'd be quite difficult to suddenly make it relevant to good character later.
Unless it's possible, in fairness to the appellant in this case, that the Secretary of State didn't realise, perhaps thought it was an error. There's a little more on the file note of paragraph 64, which is another passage I wanted to show you, Paul. But it does seem from paragraph 64 that gives more detail about the Home Office file note, and it, according to the judgment, refers to a false date of birth in the asylum application, and that it was not thought appropriate that the citizenship should be considered a nullity because the only change in detail was the date of birth. Now, at that time, the Secretary of State had a different understanding of the nullity case law, but clearly the Secretary of State in this case is aware of some kind of falsity.
Anyway, the point just wasn't raised.
Yes, and the point wasn't raised, but there are 2 reasons in my submission why Sleeman is different. Not just that the point wasn't raised, which is the paragraph 65 point, but to fully understand this decision, in my submission, the court also needs to be aware of what the Home Office file note said at the time and contrast that with what was said in the file notes in this case.
As you say, it's quite difficult. I mean, because we don't have the file note, I think you were submitting that it needs to be cautious about the weight placed on the references to it in this decision.
Yes.
Because, as you say, one doesn't know what the effect of that was, what
Yes.
conclusions were drawn from that.
Although insofar as they are referenced in the decision, they indicate that the case is different from
Yes.
this one, which is a further reason why this decision did not have the effect that the upper tribunal intended it to have.
So the first tier tribunal.
The first tier tribunal, exactly.
Yes.
So your point basically is the Secretary of State was aware that he'd given a false date of
Yes.
birth as well as his true date of birth at the time when ILR was being considered, and expressly stated subject's age was irrelevant.
Exactly. And then didn't go on, as we know, to take a point on good character.
Yeah.
And it's also important, in Sleeman, the tribunal expressly does not consider itself to be setting out a general proposition, because at paragraph 61 it asks the question, it says the fraud has to be directly material to the decision to grant citizenship. Was it directly material in this case, is the question, and then it goes on to consider the very
Yes.
specific facts.
Yes. Which, as you say, is a question in every case. So it's dangerous to draw.
Indeed,
Yeah.
particularly as the court will have seen that in this case, the judge even perhaps expresses some surprise that a point wasn't run that could have been, and there we are. So we think 2 points about Sleeman. Clearly it turns on its own fact, and it's not authority for the proposition it's said to be authority for. So the first tier tribunal was wrong to treat it as determinative or materiality. We say that the case of Matusha if any case is to be looked at, is more relevant. And second, it's what the tribunal needed to ask itself was whether the fraud, etc., was material to the acquisition of citizenship. So, in my submission, it's clear beyond doubt that the first tier tribunal erred, and the upper tribunal was right to set its decision aside, and that, in my submission, disposes of the appellant's ground of appeal. It must fail. Just on the authority of JK, we say that doesn't take matters further forward because that was about undermining a decision on a point of fact, rather than about whether the court had misdirected itself in law. And at the risk of repeating myself, a misdirection is not converted into a correct direction because the court or tribunal was assisted in its error by one of the parties. It's still an error of law. Briefly, on the legacy cases that have been handed up, can I make a point of principle here, which is this? Our simple point in showing this court Matusha is to show, to illustrate why the first tier tribunal erred in treating Sleeman as determinative, and in showing actually what happened on the ground at the time when the Secretary of State's ILR decision was made in this case. But one has to be cautious about delving into the legacy programme because the issue in this case is, did the first tier tribunal make a material error of law? If it did, then nobody is challenging the upper tribunal's decision to remit. So any arguments that the appellant wants to advance on public law will need to be advanced in the remitted appeal, and he will need permission to advance those arguments. But this court is not deciding whether or not the decision was in accordance with the Secretary of State's policy. We say in any event, there's nothing to assist the appellant in any of these authorities on the legacy programme, because the fact is that by his deception, he deprived the Secretary of State of the opportunity to consider his case. So it's no good for him to say, well, in a counterfactual world, I might have had better luck, that those aren't his facts, he lied. And nothing in any of those authorities can convert the first tier's wrong decision into a correct decision. So those are my submissions on ground one. Could I then turn to the Begum issue? Does Begum apply? And I'm proposing to deal with this in 5 parts.
What do you want to say about your respondent's notice?
It's
or is that really just dealing with Begum?
It deals with Begum. Out of an abundance of caution, we made the additional point that the first tier tribunal wrongly treated Sleeman as determinative.
Right.
But my learned friend dealt with that as part of his ground of
yes,
appeal.
It's not. Yes.
And that, I think, deals with the issues in our respondent's notice.
I think properly analysed, it is a respondent's notice point because, as you pointed out, the upper tribunal said, I decide this on the second ground.
Yes.
But you're right, it's before us through both of your helpful submissions.
Yes, and I tend to be ultra cautious because I think applicants always fear turning up to court and being asked why that wasn't in a respondent's notice. But yes, I think properly it's a respondent's notice point because it's not what the upper tribunal's decision is. Quite simple. It says effectively misdirection. But
right.
That's
okay.
a discrete error.
Yes. So that leaves Begum.
That leaves Begum. So I was proposing to take that in 5 parts. So first, to deal with some specific points on the statutory framework in the 1981 Act. Second, to deal with things chronologically, to look at the upper tribunal's decision in Pirzada, which is also expressly referred to in Begum, but this time with approval.
That was mark our foot on this judgment?
Yes.
Yeah. Sorry.
Third, then I will take the court to Begum in some detail, because the crucial question is what Begum decides. And then fourth, I'll draw those strands together and set out why we say its reasoning also applies in this context.
Yes.
And then finally, I will take the court to a couple of recent upper tribunal decisions on this point.
Okay.
So starting with the statutory framework, Mr Southey has already explained the history, and the court has the original provision in the 1981 Act. We don't need to turn it up, it's at tab 56, page 1411. And the position is that, in fact, the fraud provision goes back to 1914, and I'll show the court that in a moment in Al Jeddah, which describes the history. We then get a 1948 Act, a 1981 Act, and then the changes made by the 2002 Act. And again, Mr Southey has helpfully taken the court to those changes, but just for the court's note, after 2002, see tab 56, page 1418, section 40, as it was inserted by the 2002 Act, and see tab 57, page 1428 for section 40A, and then to complete the picture at the same time, section 2B was introduced into the Special Immigration Appeals Commission Act 1997, and the court has that at tab 37, page 1026. So at that point, could I ask the court to turn up Al Jeddah at tab 9? And to read paragraphs 14 to 17.
Sorry, tab 9.
Tab 9. 14 to 17, which set out the history. And for the court to note, the history goes on until paragraph 22 in case of interest, but for now I'd only ask the court to read paragraphs 14 to 17.
Yes.
So that explains some of the history, and it also explains why section 44 does not apply in a fraud case. And then there's a longer passage about the history in relation to statelessness and changes in the 2002 Act, and that ends at paragraph 22, but I don't ask the court to read it now. So with that history, and before I launch into Begum, could I make 3 brief points, perhaps obvious points, on section 40, which is in tab 36 at page 1002.
Yes.
So the first point is an obvious one, that the test in both section 42 and section 43 is the same. It's that the power to deprive can be exercised if the Secretary of State is satisfied that. Now, section 44, and this is my second point, is an exception to the general power of the Secretary of State to make an order under section 40.
Yes.
But it only applies to section 42. And I will deal later with the submission that was made by Mr. Southey that also contains the words is satisfied that, and therefore undermines the Secretary of State's argument. We say that that's wrong. And the third general point to make about section 40 is that where there has been wholesale impersonation of another person, this provision isn't engaged because the citizenship would be a nullity. And that's dealt with. This court doesn't have it and doesn't need to have it, but that was the situation, that was the issue that culminated in the Supreme Court's decision in Hysaj, or Hysaj, which is probably referred to in some of the later authorities. And then turning over to 1006, which is section 40A1, again, could I make three key points about the legislation itself?
Yes.
Is that section 40A1 confers a right of appeal for both conduciveness decisions and fraud decisions. And indeed, there are conduciveness appeals proceeding in the tribunals that aren't in SIAC. So it's not the case that conduciveness is always in SIAC. It will only be in SIAC, and this is my second point, if it's certified under section 40A2. Now, we say it's important to look at the reason given by Parliament for certification into SIAC. When one's looking as a matter of statutory construction, what the right of appeal is, and when one's looking at Begum, it's important to see that the reason that an appeal goes into SIAC is because the Secretary of State certifies that it was taken wholly or partly in reliance on information which should not be made public. So for those listed reasons, and of course SIAC has special procedures for dealing with closed material. And the important point from a statutory construction perspective is that nothing in that provision says that it goes into SIAC so that SIAC can consider the appeal on a different basis. It's simply so that SIAC can apply its procedures.
Well, actually, it says that subsection 1 shall not apply. So, where does it say that you can appeal a decision that's within the scope of 40A2?
That's section 2B of the 97 Act, isn't it?
Yes.
So it created a different route.
Yes, it's right. So you don't. So the starting point is there is a right of appeal to the tribunal for both a conduciveness deprivation and a fraud deprivation. Yes. But if on a conduciveness deprivation, I suppose in principle it could happen in a fraud case, but it seems unlikely to be the case. It would usually be in a conduciveness situation. If the Secretary of State certifies that that deprivation decision has been taken on the basis of information which should not be made public, there is not a right of appeal to the tribunal, but there is then a right of appeal to SIAC, and that's tab 37, 1026.
Yes.
But fundamentally, in terms of scope, the appeals are the same. The only difference is that one of them is based on information which the Secretary of State has certified shouldn't be made public.
Can I just, are you going to deal with section 40A3?
Yes, that was my third point.
Right, okay.
So my third point is this, that an appeal under section 40A has never been permitted to be made on the ground that the discretion should be exercised differently. And Mr. Southey helpfully confirmed that yesterday in his submissions. So to answer a point that Mr. Southey made in oral submissions, the fact that Parliament introduced by Section 40A a right of appeal says nothing about the grounds of appeal which the tribunal is entitled to consider, and that's one of the fundamental points that's made in Begum. And to pick up a point that was made yesterday in the course of oral submissions by my lady, we say that the fact that the Parliament has never applied those broader grounds of appeal in a deprivation appeal is telling. We say it supports the Secretary of State's position. Because if it was Parliament's intention that the tribunal should be able to consider a deprivation appeal on the grounds that the discretion should have been exercised differently, why not just apply Section 86 when it was in force? But it didn't. Mr. Southey's point is, well, it introduced the right of appeal, and it introduced the right of appeal to a tribunal which was entitled to decide discretion issues, at least originally. But that rather misses the point that Parliament expressly did not permit those grounds of appeal to be considered, or certainly that's inaccurate. What it did was not apply Section 86 of the 2002 Act.
Well, yes, I mean, it's silent
It's silent,
on
but
the scope of the appeal.
yes, it's silent on the scope of the appeal, but we say it's telling, at least, that it did not. While it turned its mind to applying certain provisions of the 2002 Act, it expressly did not apply a provision which, at one time, permitted a tribunal to consider an appeal on the grounds that a discretion should have been exercised differently.
But if you go back to 1981, this, I thought I understood from Mr. Southey's submission, that this was the first time that the right of appeal was introduced
Yes.
in respect of deprivation of citizenship. Prior to that, you had to go by way of JR.
Inquiry, it was called, yes.
Or
Yes.
but was it the equivalent of judicial review?
Don't know the answer to that. I think it was a fundamental
an
difference.
inquiry.
There was a statutory individual that was appointed who would make that, and there was authority for the proposition that that individual's decision could be judicially reviewed.
Right.
That was my understanding.
Is that right?
That's, I think, I'm not sure about authority for the judicial review. I don't think it was ever tested, because as far as we can work out, the individual never actually had to exercise that jurisdiction. That's what Fransman seemed to suggest. So there's little understanding of how that operated in practice, because it doesn't seem to have operated in practice.
You mean so you could whatever, however it was described, you could challenge the decision by way of inquiry to the named individual. But you're not aware.
I think it may have been a committee, but yes.
Committee, but you're not aware of that ever actually having happened.
Fransman suggested it never actually happened.
And how long was it in place for?
I think, yes, yes. It must have been 1981 to 2002, because 2002 is when the legislation comes in, and I think the order was 1981. But it appears never to have been.
Right.
That's the suggestion from Fransman, as best as anyone can tell. On the face of it, it would appear to be judicially reviewable because it was an administrative body. There's no obvious reason.
No, I didn't mean that. I mean, what was the nature of the power given to the scope of the power given to the committee?
We have referenced, there's secondary legislation for it. We've referenced that. We haven't included that in the bundle. We can obviously provide that if it would assist. Oh, they are in the bundle. Sorry, I'm told that the review rules are in the bundle. There are the...
Just a matter of interest, because that's the context for the introduction of this provision, isn't it?
Yeah.
Yes. Which tab of the rules, please?
42, I think I'm told.
Right.
So perhaps it's important just to start with the the original provision in the 1981 Act, which refers to the inquiry. So that...
Sorry, I've rather forgotten where is the original provision in the 1981
Yes, so
Act.
it's page 1411.
1411.
Tab 56.
Sorry, you said that before, yes.
And fundamentally it was the same in the British Nationality Act 1948. So if the court looks at 1411, the court will see it 40 sub 1 is the fraud power.
Yes.
And then at 43 there's a different version of what we're now used to as the conduciveness power.
Yes.
And then at 40 sub 5 we'll see that the section 43 power can't be exercised unless it would be conducive to the public good and if it would make a person stateless, and that's part of the history discussed in Al-Jeddah.
Yes.
And then the inquiry provisions 7 and 8, if the person against whom the order is proposed to be made applies in the prescribed manner for an inquiry, the Secretary of State may refer the case to a committee of inquiry consisting of a chairman, being a person possessing judicial experience, etc. And then the Secretary of State may make rules for the practice and procedure to be followed.
Yes.
In connection with references under subsection 7. And one of the points, as I recall, that was made by Mr. Southey in writing, but not orally, was a point about the secondary legislation, which is the rules that are in the bundle. And our answer to that is secondary legislation could not expand the scope of the appeal. It could not confer jurisdiction.
Well, what subsection 7 says is that if a person applies in the prescribed manner for an inquiry, then the Secretary of State can refer to a committee of inquiry.
Yes.
So there's nothing in that that defines the scope of the inquiry.
Yes.
Although subsection 8 does say, does give the rulemaker power to make rules which can confer on any such committee any powers, rights or privileges of any court.
Yes.
So to understand the scope of the committee's powers, we need to look at the rules, don't we?
Yes.
So your submission that the rules can't change.
They can't expand. What it says is powers, rights or privileges of any court. It doesn't specify the basis on which the court is to proceed. But in any event, it's by the by, because the rules don't, in any event, in my submission, don't really take matters much further forward. I'm realising I'm answering a submission that Mr. Southey hasn't made orally.
No, so where are the rules again?
Tab 42.
Sorry, which?
Tab 42.
Thank
Tab
you.
42.
So rule 4.
Sorry.
Now, just to be clear, these aren't only applicable to fraud cases. They're also applicable to conducive cases. So,
Yes.
so in my submission, and I'll come on to Begum, it's rule 4, I understand, that's relied upon. The committee shall give to each party an opportunity to address the committee, to give evidence, to call witnesses and to make representations on the evidence and on the subject matter of the inquiry generally. The committee may receive oral, documentary or other evidence of any fact which appears to be relevant. The committee may at the inquiry request the Secretary of State to furnish an explanation. Now this was the same in addition for the conduciveness power.
But a general inquiry that includes actually an obligation to give to each party the opportunity to give evidence and to call witnesses and to make representations.
Yes.
So there's yes.
And the committee can receive any evidence which it thinks is relevant, even if it's not admissible in a court of law.
Yes. That was equally the position, as I say, for conduciveness appeals, and which is why the reason I make that point is because we say Begum trumps effectively.
Yeah, I understand that.
Yes.
But it's interesting, as my lord was asking yesterday, why give a party, why require a committee to enable a party to give evidence if, in effect, what are you doing with the evidence?
Yes, and of course it's difficult to answer that if we can't give a concrete example of what actually happened in practice, and these rules...
I'm just thinking, if you're saying you're not actually making a decision yourself, you're actually just reviewing on public law grounds, the Secretary of State or whoever was making the decision, Lieutenant Governor, what's it for?
Yes, although
witnesses.
One has to bear in mind that this was not an appeal process. It's almost a one-stop shop. So it's not like Section 40A. It's a completely different process. It's a committee of inquiry, and it's almost apples and oranges between this and Section 40A. So for what Section 40A means, one has to look to Begum, and one has to look to the language of Section 40A read with Section 40. And I simply can't answer that question because it appears that there wasn't an inquiry and there hadn't been an inquiry. These are the rules that were drafted, but they relate to a discrete inquiry process, which was a very limited means of challenging a deprivation decision.
Begum makes it clear that there will sometimes be issues of fact which need to be determined,
Absolutely.
and no doubt you're going to show us that. So all this is doing is making provision, for example, evidence about whether there was a fraud, which is a binary question of primary fact.
Yes, so we say that Begum makes clear that that's a matter for the Secretary of State rather than a question of fact for the court, but we do say nothing in this can take matters really much further because it can't define the scope. It can't define the scope of an appeal which hadn't been introduced, and similarly, since the process doesn't appear to have been used, I can't say, well at the time though, the Secretary of State
I understand that, but that is the background.
That's the background.
And can you remind me why that was replaced by the right of appeal in Section 40A?
Because that was introduced by the because of right of appeal was introduced.
Sorry.
Effectively, perhaps if
but was there something specific that led to it? There wasn't. It just
partly in conduciveness cases. There was a decision of the European Court of Human Rights called Chahal, which I'm looking at Mr. Southey, who's more experienced.
that decided that then procedure was not
process was not
Article 6
CHR
compliant. Right. Well, that's right.
Shahal was dealing with the three wise men in national security cases.
It was also considerably earlier, I think, because it was pre-human rights. I think it was about 1997.
Yeah, because I think that's what led to the enactment of the 1997 Act.
Yes, exactly. SIAC was either just before or just after Chahal, because it was anticipating the argument. Yeah.
But was it similar? You see what I mean? So maybe somebody. Anyway, I'm probably being too speculative.
I think maybe because there's a 5-year gap, and SIAC certainly was a response to Chahal.
Yeah.
But that was the 1997 Act, and that didn't include a citizenship appeal. So I think, yeah.
But it's all of a piece with 97 establishing SIAC as a response to Chahal. You have the 98 Human Rights Act. You then have a whole-scale review of procedures to see whether or not they're likely to be compliant. And you can well see that people might decide that an inquiry that's never used would be better replaced by a first-tier tribunal.
Well, I think what I would say is that certainly the 2002 Act was a wholesale review of, not just because of the UCHR, but a wholesale review of immigration procedures to modernise them.
Yes.
Yeah.
And some of this history is addressed in paragraph 22 of Al Jeddah. So not in full, but what it says is it makes a point that 316 of the bundle at letter E.
Sorry.
Sorry to jump
It's
around.
about a 9, isn't it?
So tab 9, back to Al Jeddah,
Paragraph.
22. That explains the background to the 2002 Act.
Right.
I'm sure if it would assist the court, Mr. Southey and I could put together an agreed note, draw together these points on the history.
Yes. Yes.
I'm volunteering Mr. Southey, but he's
You have.
smiling.
I'm literally going on annual leave, which is why I'm not around tomorrow and why the matter was listed in this way. So I may have to pass the buck back for the first draft, but
That's fine. If the court were happy to allow Mr. Southey to take his leave, we could certainly. I realise this isn't crucial, but if it would assist the court, we can certainly.
I think it would.
use that.
I think it would.
Yes. The other, I had found a case called Hicks, which is about the conduciveness power, but it does set out the history of the fraud provision. It sets out exactly what the older provision said. So we can put all of that together.
Thank you.
And the excuse me. The rules that address the nature of the inquiry are obviously replaced by tribunal rules
Yes, and SIAC rules.
and SIAC rules. And do we have those in the bundle?
We don't, although they will obviously cover non-deprivation appeals as well.
They
They're
will.
the upper tribunal procedure rules in the first tier. We do have the FTT rules in the bundle, I'm being told.
So these are made under section 40A, subsection 3, is that right?
not any longer. They're now made under the Tribunals and Enforcement, Courts and Enforcement Act, because that establishes the FTT.
But what we get is in section. Thank you. What we get, as my Lord Justice Moylan pointed out, is that certain what section 40A(3) does is apply certain provisions of the 2002 Act, including section 106, which relates to rules
Yes.
and practice directives.
So we have, so the rules set out just a matter for interest, where do the...
Yes, so tab 44, as Southey's helpfully telling me, is the first tier
Yes.
tribunal procedure rules.
And where do they deal with appeals?
The whole thing is about appeals.
Oh, the whole thing is about
effectively.
appeals. This is the appeals.
Sorry, which tab are we now?
Tab 44, and just looking at the enabling power on page
Yes.
1069, the court will see section 106(3) of the
Yes.
Nationality, Immigration and Asylum Act and section 40A(3) of the British Nationality Act.
Yes. Thank you.
And this does include the right to call evidence.
It does,
Paragraph 14.
yes, although of course we will say that the tail can't wag the dog. that these are subject to the scope of the appeal in
It
the
depends
first
on what
place.
the dog is.
Yes, well that's what I'm coming to. The dog is
If it's
Begum.
an unidentified dog.
Yes, Begum. The dog is.
I mean, the
Begum,
position
I
under
say.
in the site rules is broadly similar, isn't it? You've got, there are provisions about witnesses and taking oaths and evidence and all the rest of it.
Yes, because of course some SIAC appeals won't be deprivation appeals, so they will be broader in scope.
So there's quite a lot of cases that come through SIAC where they're experts on statelessness, etc.
Yes, and that,
what are the rules in Bangladesh on X and Y?
yes, and I'll deal with statelessness when I'm dealing with Mr. Southey's points, but that's right.
So there's nothing, is there anything in this about the tribunal's powers on an appeal? Was that in the statute?
That would be in statute. So, for example, in a 2002 Act appeal, we don't have those provisions in front of us, but there are provisions about what the tribunal can do with an appeal.
Which section do you happen to know?
Section 84, I think. Off the top
Is
of my
that
head,
sort
but
of
I will-
similar to the power of the, it wouldn't be similar to the power of the Court of Appeal. So what, I mean, is it generally to,
I
you can't bring it
I've
to
been
mind.
making it up.
Section 84 of the 2002, did you say, Act?
Yes,
2007 Act.
This will be the 2002 Act.
We're checking,
Okay.
Yeah.
but there isn't.
There's a group of provisions about appeals.
There are, yes.
Somewhere in the
There's-
early to mid 80s.
Yes, it begins at section 82. I know that, but
Yeah.
I can't. It's sections 82 to 86, I believe, but I can't.
And they were significantly amended by the 2014 Act.
They were.
So the scope of appeals was much, in essence, much broader before the 2014 Act and has now been
Yes,
narrowed down to.
exactly.
Is this history set out in Begum as to the, do they analyse those provisions in
I think
Begum?
so.
No,
No.
no, we can deal with that in our the history, and we can add where those.
Well, I think for myself it would be very helpful before you both conclude already to have the provisions which set out the grounds of appeal on section 40A.
That there aren't. They don't.
42.
That there isn't anything. That's the issue. That's why.
So
That-
section
that's-
84 doesn't engage.
No, it does not. I mean, that's one of my points.
Yep.
that In the 2002 Act, originally there were a detailed list of immigration decisions and a detailed list of grounds of appeal, including that the discretion could be that the tribunal would exercise a discretion differently,
Yeah.
but no such provisions have ever appeared in
Yes.
the 1981 Act, nor have they been applied by the 1981 Act.
Even though there's a mechanism in the 81 Act.
Exactly.
Yeah.
And that was the point that your ladyship made yesterday in argument, which is the point might be made that given that there's a mechanism to apply provisions of the 2002 Act, it's telling that those provisions which set out grounds of appeal weren't did not apply the grounds of appeal provision. So that's essentially why Begum is so important, because the legislation does not spell out the basis for the appeal, but Begum tells us, look at the case law, that tells you the basis on which the appeal can be brought.
And sections 82 to 86, wherever it is, just say, set out the powers of the tribunal, say to set aside the decision or whatever it might be, but give no indication as to the basis on which the tribunal can set aside the decision.
They do, because that comes from the grounds of appeal. So it used to be a whole list of about, I think,
Yes.
about 8 to 10 grounds on which an appeal could be brought, but now the grounds are much more narrowly confined. So it's that there was an interference with human rights, or that it breaches the Refugee Convention, or that I think there are 3 grounds now. Yes, I'm very helpful. It's a miracle, I think I was right. Section 84, grounds of appeal,
In the 2002 Act.
in the 2002 Act. So the old grounds of appeal, up until they were amended in 2014, include things like the decision is not in accordance with immigration rules, decision is unlawful under Section 6, breach of EU rights, decision is otherwise not in accordance with the law, and that was a broad ground of appeal which was lost. The person taking the decision should have exercised differently a discretion conferred by immigration rules, and that removal would breach obligations under the Refugee Convention or Section 6.
So that was up to 2014?
Yes, and then it changed fundamentally, as my lady has indicated.
Thank you.
Yes, my memory's better than I thought, and it's section 86, which deals with determination of appeal. And again, I'm reading from the original version of the 2002 Act. It says the adjudicator must determine any matter raised as a ground of appeal, and any matter which section 85 requires him to consider. That's a complex provision about new matters, and that's been amended over the years. And then it says the adjudicator must allow the appeal insofar as, and then it sets out the basis on which the appeal must be allowed. And I'm being told that at tab 41, yes, at tab 41, turn to page 1053, we have section 86 as it was
I see.
at the time that the 2002 Act amended the 1981 Act.
So this was before the revision in 2014?
It was.
So very likely to be the original version then?
Yes.
Yeah.
And it's section 86, which of course will look different now, but that's essentially the statutory provision which deals with determination of appeal. And then 86.5, otherwise the adjudicator shall dismiss the appeal.
And 3B is the subsection 3B is the provision that deals with exercising.
Yes,
different
and
exercise of discretion.
that matches up with the broader grounds.
Yeah.
We've got section 82, but not section 84, but we can
Yes.
provide that.
Thank you.
Yes.
So on then to the second part of my submissions in this section, which was just to take the court to Pisada, which is at tab 16.
Sorry, can you remind me why we're going to this?
I'm going to this because it's expressly referred to in Begum,
Okay.
which I say is significant. So the court may recall that Lord Reed was unimpressed with the tribunal's jurisprudence on the scope of section 40A appeals, but he wasn't unimpressed with this case, which is Pisada.
And after Pisada, Mr. Justice Laing revisited Pisada and Delasis and said he was right in Delasis.
Yes.
Yeah. In BA, I think it was.
In fact, Pisada is March 2017. Delia Lisi and AB, which were AB is referred to, and that is at tab 15, and that's an earlier 2016 decision. And Delia Lisi tab 8 is Delia Lisi, and that's 2013. So actually, Pisada comes later.
Well, it was Delia Lisi, then Pisada, and then BA when Mr. Justice Laing said I was still right in Delia Lisi.
It was, I think it was Deli Alisi and then
Pizarro.
AB and then Pizzarda, and then there may have been a following decision.
There was
where
BA.
Yes, BA, which we don't have.
No,
Where
but
Judge
it's summarised in Bacon.
Yes, that's right, where Judge Laing says I was right.
Yes.
So the conclusion, and this is important, the head note, on the top of page 500, this is Pizzarda.
Yes.
The power under subsection 3 only arises if the Secretary of State is satisfied that registration or naturalisation was obtained by fraud, false representation or concealment of a material fact.
Yes.
Deception must have motivated the grant. Well, yes, we know that. So the facts of this case begin at paragraph 2, and then the deprivation decision, paragraph 6. So this is an appeal against a deprivation decision on grounds of fraud. It's an odd case. It was somebody who was practising medicine who shouldn't have been practising medicine. Now, the conclusions that the tribunal draws from the statutory provisions are at paragraph 9, and for my purposes the important one is C. The power under subsection 3 arises only if the Secretary of State is satisfied that registration or naturalisation was obtained by fraud, false representation or concealment of a material fact.
Yes.
And then the first tier tribunal sets out the first tier's decision, and then the Secretary of State's decision is at paragraph 11, and then the core parts of the decision are the cited paragraphs 9 and 11. So at the bottom of 504, it's noted when you applied for British citizenship in 2008, you were already engaged in the medical profession, but you didn't mention on your naturalisation application that you were not a fully qualified doctor. So he hasn't been convicted yet, but he's up to no good at the time he makes his naturalisation application. By deliberately withholding such information, your application succeeded. However, had it been known that you were not a fully qualified medical practitioner, but still engaged in medical practices, you would have failed the good character requirement. And again, that's repeated in paragraph 11.
Yes.
And then dealing with the first tier decision at paragraphs 12 onwards, and then importantly at paragraph 16, it therefore appears to us that Judge Hopkins was entirely right in looking to see whether the Secretary of State was entitled to conclude that the claimant's naturalisation has been obtained by conduct of the type set out in section 43. So this is not a Deli Alisi discretion issue. It's directly about the condition in section 43. And then it goes on to say, evidence to the claimant's general conduct does not and could not do that. In order for the power under section 43 to be exercisable, there must be an identical deception of the sort listed in that subsection, which can be shown or properly assumed to have been operational in the grant of naturalisation. And then dealing with the specific facts of this case, it says it's difficult to see that a person ought without any specific question to be regarded as not disclosing relevant material if all that's said is that you may have committed a criminal offence and been charged with it. So there's nothing wrong with the first tier decision. However, then Pizzarda is actually a case about not owning up and therefore being treated as of good character. So that is addressed at paragraph 17 to 19. And then importantly, at the end of paragraph 20, further, although that part of the application might have generated the power under section 43, the discretion is the Secretary of State's alone. But the important part of this case is that, and it's reflected in the head note, which is that it is about the condition, it's not simply about the discretion.
Yes, but what the upper tribunal judge did was endorse what the first tier tribunal judge had done. Is that right?
Yes.
And we find that from paragraph 32 at the
Yes.
top of page 506, where the first tier tribunal judge said the issue for me is not whether he's a person of good character, it is whether he obtained his citizenship by means of fraud.
Yes.
Isn't this reasoning over to it? Because in paragraph 21, the tribunal says, the claimant's case is very much like one in which the decision of the sort against which he appealed would not merely be permissible but entirely justified. But we agree with the first tier tribunal judge that no lawful decision has yet been made. We therefore dismiss the Secretary of State's appeal.
Yes, which indicates that the tribunal thinks it's for the Secretary of State to make the decision.
It depends which decision you're talking about. And that's what Lord Reid emphasised in
Yes.
Begum, because this decision makes it clear that the decision on fact was for the FTT and the upper tribunal by way of review. But discretion is, of course, for the Secretary of State.
Yes,
And there's a big hint to the Secretary of State, if you make a proper decision, you might well succeed.
yes, in which case it's not the tribunal making a factual decision, we say,
It is making a factual decision, first of all, that in fact the fraud on which the Secretary of State had relied had not been made out.
So, because the FTT allowed the appellant's appeal, the Secretary of State then appealed against the decision of the FTT
And
allowing
failed.
the appellant's appeal, and the upper tribunal dismissed the Secretary of State's appeal.
perhaps it's most useful to look at what Lord Reid says about
Yeah.
Yeah.
Pirzada, because it's the only, it's clearly, and one sees that from the head note, it's a different approach.
Well, yeah, except, sorry, just going back to what the first tier tribunal judge, the first tier tribunal judge was not approaching it on the basis of, I have to decide whether the Secretary of State was entitled to decide what she decided. It was the issue for me is whether he obtained. So that was the issue he or she had to decide.
But also the question dealt with in the head note is in what circumstances the Secretary of State can exercise the powers of deprivation conferred by subsections 2 and 3. That doesn't on its face deal with the separate issue of what issues the FTT is considering in an appeal against the exercise of those powers. Because
Yes,
they're two distinct things.
Although if one looks down to 5, it says the grounds of appeal are limited by the formulation of section 40 and must be directed to whether the Secretary of State's decision is in fact empowered by that section. There is no suggestion that a tribunal has the power to consider whether it's satisfied of any of the matters set out in subsection 2 or 3. So that's a discrete point, and then nor is there any suggestion that the tribunal can itself exercise the Secretary of State's discretion. So it separates out those two questions.
Well, there is a distinction between the facts and the discretion. At the moment, some of the submissions and some of the cases below seem to, after Begum, seem to conflate the two. And Lord Reid didn't.
Well,
And indeed, this decision couldn't be approved by Lord Reid if he thought it was wrong for the first-tier tribunal to make the decision on the facts about whether the Secretary of State was right to find fraud.
let me make my submissions about Begum, because I hope
course.
that will make our position clear, because fundamentally we say the question for the tribunal is exactly what this head note says, which is, was the Secretary of State entitled to be satisfied that the condition precedent was met? And to the extent that that involves a question of fact, that can only be tested on Wednesbury principles. That is our position.
Does it say that in the head note?
What it does at the bottom of 5 is says a tribunal does not have the power to consider whether it's satisfied of any of the...
But that was having decided the question of fact against the Secretary of State, instead of, which the tribunal obviously wanted to do, saying, look, the Secretary of State should have been right and should have found about you on these grounds. We can't do it. We don't have the power. That's nothing to do with the review of the facts in this case.
Well, we say if a tribunal doesn't have the power to consider whether it's satisfied with any of the matters considered in 2 or 3, the tribunal can't consider for itself whether the condition precedent is met. The question for the tribunal is it satisfied that the condition precedent is met?
Thank you.
Sorry, say that again?
The question for the tribunal is not, I ask myself whether the condition precedent is met. The question for the tribunal is, was the Secretary of State entitled to be satisfied
yes, okay,
that
I understand
the
that.
condition precedent was met?
But is that what the first-tier tribunal judge was doing in paragraphs 32 and 33 of his decision set out on page 506?
I would need to read that passage again, because certainly my understanding of this case, and particularly from the head note, is that it's dealing not just with discretion but with the prior exercise.
It is, because it's saying, I turn to the question whether the appellant has concealed a material fact. None of that is, was the Secretary of State entitled to decide. It's the first-tier tribunal judge deciding for themselves whether the appellant has concealed the material fact on the evidence available. Isn't that what's happening?
Well, that may, because this case is about quite a specific point, that may not have been the best use of language by the first-tier tribunal, but we still say that fundamentally the question is as it's cast in the head note. And that does, in my submission, come from Begum.
Well, let's look at Begum.
Yes, let's look at Begum,
Let's look at Begum.
which is at tab 21. And we say that there's an important point that one has to have in mind here, which is to separate out what Begum says about jurisdiction on the one hand from what it says about deference in national security cases on the other. And my learned friend has focused on deference in the national security context, but that's to miss a crucial and we say binding part of Begum, which is about jurisdiction. So it's at tab 21, and I will take this slowly if I may. So paragraphs 28 to 31 say that the starting point is to consider the jurisdiction and the powers of SIAC.
Just to help me, the argument that was advanced on behalf of the Secretary of State in Begum was presumably specific in its scope.
There were 2 discrete issues because there were 2 discrete challenges. So one was an appeal against the refusal of entry clearance, and the other was an appeal against deprivation. So in fact, what comes from later passages in the judgment is that it was the appellant and the intervener who raised the upper tribunal decisions.
And what was challenged, if you look at page 595 in the middle, the Court of Appeal wrongly sought to reach detailed conclusions about the precise weight of the national security risk on the claimant's return. Is that the essence of the...
Well, but there's a whole series of it. Was an incredibly complicated case, and I think my lady can probably confirm how complicated it was, having been inside.
Because as well as appeals against the refusal of entry clearance and the deprivation decision, neither the Court of Appeal nor the Supreme Court was considering an appeal against a final decision of SIAC in relation to the merits of the deprivation decision. That's the first point. What had come to the Court of Appeal against the Supreme Court in relation to the deprivation appeal was, I think from memory, 2 out of the 3 preliminary issues which SIAC had considered. There was also an application for judicial review of the refusal of entry clearance because of the limited nature of the Section 2 appeal against the refusal of entry clearance. I mean, it is very complicated.
Yes.
Okay, thank you.
The ladyship has summarised it much better than I ever could, and it's right to say that in fact on the substantive issue of deprivation that has been back to SIAC recently, and there's been a decision which was included in the bundle but don't need to trouble the court.
For which SIAC gave leave to appeal to the Court of Appeal, so that'll be coming here at some point.
Yes, that will be on someone else's desk. It was incredibly complicated, but it's incredibly
Right, sorry, you're taking us to, interrupted you. Which paragraph?
It's important to understand that the court begins at paragraph 28 by
Yes.
looking at the jurisdiction and powers of SIAC. So the heading is important to understand what follows. This is about jurisdiction.
But just pausing there, the particular issue in the deprivation, the particular preliminary issue in the deprivation appeal, with which paragraph 28 is concerned, is a discrete issue about whether or not the Secretary of State breached her extraterritorial human rights policy.
Yes.
And that's why the passage which Lord Reid cites at the end of paragraph 28 talks about the judicial review principles.
Yes.
Because the question that's referred to in that passage is not the overall deprivation appeal. The question that's referred to in that passage is whether or not the Secretary of State breached the extraterritorial human rights policy.
Yes, because
it's really important to understand that, I think.
Yes, because the human rights issue was, in fact, it wasn't an ordinary human rights issue. It was an issue about whether the Secretary of State complied with her policy.
Exactly.
Yes. There's reference to paragraph 31 to Chahal, the reason why SIAC was created, and that explains it's a different process, but there was a right to make representation to an extra statutory panel, and in Chahal the European Court decided that this procedure was inadequate to safeguard rights. And then paragraphs 32 to 37 are dealing with the discrete issue about whether the refusal to grant leave to enter was a breach of human rights. And then we come on to paragraphs 38 to 81, which do deal with appeals to SIAC under section 2B of the 1997 Act. And the Supreme Court does that by starting with what I'll call the master provision, which is section 40A. So the entirety of this passage, from paragraphs 38 onwards, is important. So the court says at 38, appeals against deprivation decisions have an entirely separate history, such decisions not being immigration decisions as was understood, and then it gives some history of the rights of appeal in paragraph 38. And then, in answer to questions from the bench at paragraph 40, there does not appear ever to have been any statutory provision relating to the grounds on which an appeal under section 2B may be brought, the matters to be considered or how the appeal is to be determined. The same appears to be true of an appeal under section 40A of the 1981 Act. And then we get the examination of the fraud authority. So, in relation to the scope of the jurisdiction created by section 2B, counsel for Miss Begum and for Liberty referred to some decisions of the upper tribunal considering section 40A. The earliest of them is Delia Risi.
Yes.
And then there's a detailed analysis of Delia Risi. The key passage is at F and G on 610 of the bundle. So obviously I'd invite the court to read the entirety of this part of the judgment, but for present purposes, however, this is at F, the apparent reasoning...
Sorry, which paragraph?
It's paragraph 43 at F and G, page 610.
Yeah, I've got a loose copy that's in the weeklies, which if I'm asking you for the paragraph now.
I'll bear that in mind. paragraph, it's one of those cases that one tends to have multiple copies of.
Yeah, exactly. Well, I just want to have one.
So paragraph 43 F and G, it's a passage that begins however, which is about 2/3 of the way down. However, the apparent reasoning, this is criticising Elisi, that an appellate body's ability to retake a discretionary decision is excluded if the subject matter is non-justiciable, and 2, the subject matter of this decision is not non-justiciable, and therefore 3, this decision can be retaken by the appellate body is fallacious. It depends on the unstated premise that an appellate body can always retake a discretionary decision unless the subject matter is non-justiciable, a premise which, as explained below, is incorrect. The judge also referred in Elisi to a number of potentially helpful authorities concerned with the scope of appellate jurisdiction, but did not discuss them. It will be necessary to return some of those authorities, and then there is reference to Pizzada. And the part of Pizzada that's quoted here is exactly the part that I rely upon, which is at the bottom of paragraph 44. There is no suggestion that a tribunal has the power to consider whether it is satisfied of any of the matters set out in subsections 2 or 3, nor is there any suggestion that the tribunal can itself exercise the Secretary of State's discretion. So whatever happened in the first tier tribunal in Pizzada, what Lord Reed takes from it, and for my purposes that's all that matters, is that there are 2 discrete propositions. First, that Pizzada stands as authority, but that a tribunal does not have the power to consider whether it is satisfied of any of the matters set out in subsections 2 or 3. That is separate from the question of whether the tribunal can exercise the Secretary of State's discretion, and that is very clear language, we would submit.
I entirely agree, but there is a danger of misreading that to saying that you can't then have an appeal to decide whether the Secretary of State was right to be satisfied.
Not
And at the moment, the submissions that have been floating around in UTIAC on behalf of the Secretary of State about the effect of Begum conflate those 2 issues and say you can't look at 42 and 43 because that's what is approved in Begum. And you're right, it was approved, but that was only in relation to the tribunal going on to say, well, I'm satisfied of this. All they can decide is whether, as a matter of fact, including on fresh evidence, the Secretary of State was right to find fault. Otherwise, Pizzada would have been differently decided. They'd have said, well, we can't actually look at any of this. The Secretary of State's decided it, full stop.
What we say is that the question is exactly as here. The tribunal is entitled to, the tribunal can consider whether the Secretary of State was entitled to be satisfied of those matters.
Including on fresh evidence.
Well, there's a separate issue about fresh evidence, which I'll deal with at the end, because we say...
Because in Pizzada they allowed fresh evidence.
Well, it's judicial, we would submit as judicial review principles, and that's what the upper tribunal has decided, but one...
Where?
Well, where has the upper tribunal decided? In a case called Chimmy, which I'll take the court to at the end. But there are of course circumstances when fresh evidence is admissible in any event in judicial review. So that's a discrete question. It's certainly not one that arises in this case, of course, because there's no evidence of...
But the upper tribunal in Pizzada decided that fresh evidence was admissible because they expressly approved the approach of the first tier tribunal who had heard fresh evidence.
Well, that's as maybe, but we say that that's not... Well, one has to begin with the principle and then look at whether evidence is admissible based on the scope of the jurisdiction. So that's why one has to start with Begum and then from that work out what are the principles, will fresh evidence be admissible. And can I say that this is important because it's also arisen in the national security context, which is certainly not an issue for this court today. There have been anxious, and I'm sure my lady is, where anxious consideration of the extent to which fresh evidence is admissible in SIAC appeals, and there are 2 decisions of SIAC which deal with that issue. and they are in the bundles. They are I will get the number. It's B3 and U4, or the other way around, B4 and U3. So one, I'd certainly invite caution about the question of evidence, because that is certainly a sensitive issue in the SIAC context. I will deal with it very specifically in the fraud context, if I may. But I want, if I may, just to begin with the first principle, which is that if the tribunal is asking itself whether the Secretary of State was entitled to be satisfied that there was fraud, then the starting point is that fresh evidence isn't admissible, because that's not the right question. It's not directed to the question, which is, was the Secretary of State entitled to be satisfied? And we submit that at paragraph 44, that is what Lord Reid is telling us the question is.
But it is.
Well, he hasn't yet approved paragraph 44. Presumably, he hasn't yet approved Pazardo.
No,
he's just set it out, but you're going to show us that he approved it later on, are you?
No, he doesn't. It doesn't expressly approve it later on. I have to accept that, but it's
Right.
It's the only one that he doesn't, and it's starting to build up to his own conclusion about the provisions.
Right, sorry, can I just get a note of that? So, B
Yes, he
does not expressly approve Pazardo.
no. What he does is criticise the other cases.
Sure.
Yes.
So
we say
he does
implicitly-
not address criticism to the reasoning in the way that he does to the other decisions?
Yes, I accept that.
So is your submission that he's implicitly
Yes.
approving it?
Yes.
Okay, let me just get that down.
But because, in fact, it matches with his own reasoning, which follows.
But if he is implicitly approving it, he is then implicitly approving paragraph 13, where the upper tribunal judge specifically approves the issue is for me.
Well-
It's not whether he's good character, it's whether he's
Well, no,
going by means of material fact.
I mean, he's just dealing with that particular statement in
Yes.
Pazardo. He's not endorsing the rest of the
Yes.
reasoning.
That's exactly my submission, and it's fair to say that obviously there were practical issues arising from Begum, and I've said they've arisen in the national security context. He was not deciding the question of what evidence should be admissible. It's being decided at a level of principle, and what he's approved in my submission is not to do with the ins and outs of Pazardo, but rather the statement of principle there, which is there's no suggestion that the tribunal has the power to consider whether it's satisfied of any of the matters set out in subsections 2 or 3, and it does, his own reasoning tallies with that. But he's not, that this case does not deal with post-decision evidence. The position on post-decision evidence in my submission flows from the principle. So in terms of the principle, what he does, he then goes on to deal with BA, and as my Lord Justice Dingemans says, BA follows.
Can we just, while dealing with the issue of fact, you perfectly understandably taken us straight to Pazardo, etc. He had looked at, as you've also helpfully said, the earlier decision in Dele Alisi, but at the end of paragraph 42, he does say something quite important about facts. He refers back to Dele Alisi and says the first tier tribunal concluded that it had no power to exercise Secretary of State's discretion differently, so because it could only be by express statutory provision. Subject to compliance with the Human Rights Act, the scope of an appeal under 40A, in the view of the first tier tribunal, was to examine the facts on which examine the evidence and determine whether the basis on the decision was made out. Because that's quite important when he comes back to his formulations later on.
Yes, although that description of the first tier in my submission is talking about a Wednesbury type review, because it says examine the facts on which the Secretary of State made the decision, examine the evidence, and determine whether the basis upon which the decision was made out. So that's a Wednesbury type review.
Yeah, but sometimes examining the facts will be looking at.
I mean, it's a bit ambiguous, that passage. It's
Yes,
not really very. I mean, I wonder really whether that point was being thought about when that sentence was written, because it's not totally clear what's being said.
Yes, so on then to BA, he says in BA, this is paragraph 45, repeated Dele Alisi, and then again, I mean this is clearly critical of the approach. Laing J cited the decision of this court in Ali. However, that decision was not concerned with an appeal under section 40A, but with an immigration appeal subject to the pre-2014 version of section 84, and was therefore not in point.
Yeah.
And then Lord Reid goes on to look at cases about the scope of appeals, and the first cases that he considers are nothing to do with national security and deference. So, important passage at paragraph 46, about 5 lines from the bottom. Modern authorities concerned with the scope of the jurisdiction of tribunals hearing appeals against discretionary decisions by administrative decision makers, discretionary decisions, have adopted varying approaches reflecting the nature of the decision appealed against and the relevant statutory provisions. So the first is the case of John D at paragraph 47. The case concerned the jurisdiction of the VAT tribunal, that a taxpayer should provide security for the payment of tax. The Commissioners had a discretion to require security in terms of the relevant legislation where it appears to the Commissioners requisite to do so for the protection of the revenue. And then it says at paragraph 48, Lord Justice Neal held that the question for the tribunal was not whether it appeared to it that the provision of security was requisite for the protection of the revenue. The statutory condition was whether it appeared to the Commissioners to be requisite. In examining whether that condition that was satisfied, the tribunal would to adopt the language of Lord Laing, and then the citation there. The tribunal might also have to consider whether the Commissioners had erred. The tribunal could not, however, exercise the statutory discretion itself. And then there's reference to paragraph 49, and then paragraph 50, Banbury Vision Plus. That was distinguished. He identified the crucial feature of John D as being that the statutory precondition for the imposition of the Commissioners by security was that it appears to the Commissioners requisite to do so for the protection of the revenue. In other words, the legislature had expressly conferred on the Commissioners alone, and not on the tribunal or the court, the assessment of whether security was necessary for the protection of the revenue.
Yes, these are all dealing with what might loosely be called the discretion.
Yes, although we say that this is also a discretion, and we say the crucial point here is not so much that it's an assessment type issue, but rather that the legislation is using words like where it appears to, and in our legislation it is satisfied that.
Yes, but of what?
Yes, well,
well, that's rather important. Appears to do so for the protection of the revenue. That's the.
Yes, and there's a discrete question as to A, what does the legislation say about who decides the relevant thing, and then question B, what is the relevant thing that has to be decided? And we say that question B does not determine question A. In other words, the fact that the precondition for exercise of a discretion is an evaluative type question is not determinative. What's determinative is the language of the legislation. And I will come on to that, if I may, in terms of looking at what Lord Reid says about the express terms of the legislation. So, paragraphs 46 to 62, I've taken the court to 3 of the authorities. Now, Mr. Southey took the court to Raymond, and I see the time. I don't need to take the call back to Raymond, it's sidelined, but could we then move on to paragraph 60 to 61?
Yes.
This is a discrete point now. This is about institutional competence and the fact that there's an evaluative exercise. So looking at Raymond, the points which are being taken from Raymond at paragraph 60, he pointed out at paragraph 57, first that SIAT was not the primary decision maker and it was institutionally less well qualified than the Secretary of State. And then a further factor was the the nature of the decision under appeal, which did not involve a yes or no answer as to whether it was more likely than not, but an evaluation of risk. Now, could I just remind the court of the passage at paragraph 46, where Lord Reid says that modern authorities concerned with the scope of the jurisdiction have adopted varying approaches reflecting the nature of the decision appealed against and the relevant statutory provisions. So this part about Raymond is about the nature of the decision, which is that it's an evaluative exercise, but that's not the only relevant factor. What is also relevant is to look at the statutory provisions. And then paragraph 62 deals with democratic accountability. So paragraph 63, tying into the point I've just made about statutory provisions, considering against that background the functions and powers of SIAC in the appeal under section 2b, against the decision to deprive a person of their citizenship, it's clearly necessary to examine the nature of the decision and any statutory provisions which throw light on the matter, bearing in mind that the jurisdiction is entirely statutory. So Mr. Southey has placed emphasis on the first part, which is the nature of the decision, but that's not. That one has to also look on at the statutory provisions because the jurisdiction is statutory. Paragraph 64 is dealing with human rights issues, and there's no dispute, and it's certainly the effect of the upper tribunal authorities that where there is an ECHR issue, including in a deprivation appeal, the tribunal decides that for itself, and that's also the same in the immigration context. And then this paragraph 66, what Lord Reid does is start with the statutory language. And this we say is crucial. Paragraph 66.
I mean, we mustn't forget 65 because that contrasts the statutory review provisions
Yes.
with the right of appeal.
And also
and section 51B, which gives a rule-making power.
Yes. Which
Mode and burden of proof and admissibility of evidence.
which then doesn't affect the analysis.
Well, no, but he says clearly appeals involving questions of fact as well as points of law contemplated.
And if you have an appeal on a question of fact, you can't have a sensible appeal if you're only looking at the question of whether someone's approach was reasonable, because it may well have been reasonable, but the facts have changed.
Well, I don't accept that, and I'll explain why. So, again, stop paragraph 66. The opening words, the Secretary of State may indicate that decisions under section 42 are made by the Secretary of State in the exercise of his discretion. The discretion is one which Parliament has confided to the Secretary of State. In the absence of any provision to the contrary, it must therefore be exercised by the Secretary of State and no one else. There's no indication that Parliament intended the discretion to be exercised via the direction of SIAC. SIAC can, however, review the Secretary of State's exercise of his discretion. So that's about exercise of discretion.
Yes.
And then paragraph 67, the statutory condition which must be satisfied before the discretion can be exercised is that the Secretary of State is satisfied that deprivation is conducive to the public good. The condition is not that SIAC is satisfied that deprivation is conducive to the public good, or similarly, the statutory condition in section 43, unarguably, is that the Secretary of State is satisfied that citizenship was obtained by means of fraud and so on. The existence of a right of appeal against the Secretary of State's decision enables his conclusion that he was satisfied to be challenged. It does not, however, convert the statutory requirement that the Secretary of State must be satisfied into a requirement that SIAC must be satisfied. That is a further reason why SIAC cannot exercise the discretion conferred upon the Secretary of State. Now we say that also, that reasoning plainly applies to section 43. The condition is not that the tribunal is satisfied.
Lord Reid addresses section 43 and the wording of that by reference to Lord Wilson's speech at paragraph 78, and he actually turns to that. At the moment, I think what you're looking at is the question of conducive to the public good, and then reading it over to 43. I understand the forensic technique, but one can't say that that's what Lord Reid was saying.
What he's saying very clearly is the statutory one has to look at the statutory precondition to determine the scope of
It's the nature of the statutory condition. So the question whether or not something is conducive to public good is not something a court is well fitted to make a decision about as primary decision maker. The position may be different if the statutory condition is concerns fraud or the person mustn't be made stateless, because those sorts of questions are not in the same box as whether or not something is conducive to the public good.
They're different types of questions, but I come back to my point that Lord Reed says two things. He says the nature of the decision, and he says what the statutory provision says. And one it's inescapable in my submission that what the legislation says in section 43 is that it's the Secretary of State who has to be satisfied.
But you're not exercising a discretion if you have to be satisfied that the registration was obtained by a certain means.
No, but it's...
How is that discretion?
It's not, but it's the precondition for the exercise of the discretion. And the precondition for exercise of this is an important point, because there is some legislation, and I'll show the tribunal an example, which says if the position is X, if a person is X, if a person is a legal entrant, the Secretary of State may. But that's different from a situation where it says if the Secretary of State considers that the situation is X, the Secretary of State may. And we say this is not, one can compare it, and I will take the court to the precedent fact situation, but there's an important distinction. We say it's a distinction that Lord Reed is making here, which is it's not simply the nature of the decision, it's the statutory condition. And the condition in the legislation is not if citizenship has been obtained by fraud, the Secretary of State may. It's if the Secretary of State is satisfied that.
I understand that, but the determination whether something is conducive to the public good it's all wrapped up into the same thing. It's all the Secretary of State is determining in his or her the exercise of his or her judgment as to whether something is conducive to the public good. And fraud, false representation, or conceived, if you're trying to place weight on the statutory provision, is in a very different category.
Yes, but that does not mean that the court can determine the issue for itself. And I would take the court to the...
But you're saying we've got to place heavy weight on the wording of the specific statutory provision. What I'm simply pointing out is that the wording of subsection 3 is very different from the wording of subsection 2. And do we get anywhere in Lord Reed's judgment that he's looking at a situation, or helps us to look at a situation in subsection 3 rather than subsection 2?
Again, I mean, I can't say more than I've said. It's the words is satisfied that, and what he says in paragraph 67.
Right. Okay.
And then paragraph 68 is a separate point we submit about discretion. So appellate courts cannot generally decide how a statutory discretion ought to have been exercised or exercise the discretion themselves. That I accept is a point about discretion, and I accept that there are two limbs in a fraud case, which is the Secretary of State. The Secretary of State has to ask herself this: am I satisfied that the citizenship has been obtained by fraud? And if so, should I exercise my discretion? And she will separately consider ECHR issues. So those are the questions for the Secretary of State. I accept that paragraph 68 is focused on the discretion question, but the fact remains that so far as the precondition is concerned, it's the Secretary of State who has to be satisfied.
Can I just ask you about the passage where about 4 lines up, after the semicolon, Lord Reed goes back to an issue which encompasses the consideration of factual questions as appears in the context of statutory appeals from Edwards and Berseth. Can you help us on what is meant by that?
Is that, sorry, that's the passage beginning that they are generally,
yeah.
They're in general restricted.
And And then he ends with that bit that I just read to you. I just wonder if you've got any submissions, one way or another, on what that means.
Well, it doesn't mean that's. I don't think that's a reference to making findings of fact, is it? I think Edwards and Bairstow is.
It doesn't appear to be. I just wondered whether
I haven't.
No, sorry to be so specific, but
I haven't read Edwards and Bairstow, but I would like to.
I had a look at it several months ago. I haven't looked at it recently, but my vague recollection is that it's a case in which the House of Lords was talking about the Wednesbury type approach. Mr. Southey seems to be.
Yes, Edwards and Bairstow from memory, but I'm fairly confident this memory is a situation where there wasn't sufficient evidence to justify a finding of fact, basically. Right. So there was no or legally insufficient evidence. So,
that was my understanding, but it seemed to me that a point that the Secretary of State may want to make, but anyway.
Yes, I'm, of course, and I'll come on to this when I'm dealing with the evidence question, but sometimes evidence, post-decision evidence even, is admissible in judicial review, so whether that's the point, and I'm sorry I missed some of what Mr. Southey was saying, but
Mr. Southey said it was, his recollection was it was a case where there was no evidence to support the conclusion that the decision maker had made, so it was almost rationality, really.
Yes, and of course that will... If I'm right, and the question is, was the Secretary of State entitled to be satisfied, then of course the tribunal will be looking at evidence, but it simply won't be determining that as a factual question for itself. So, just to draw attention to the passage in paragraph 69, nevertheless, it's 5 lines down, the characterisation of a jurisdiction as appellate does not determine the principle of law which the appellate body has to apply. And again, they depend upon the nature of the decision under appeal and the relevant statutory provisions. And then a passage which I think we're all very familiar with, which is the passage at paragraph 70 to 71, that there have been cases in SIAC which make clear that it's not simply these public law grounds, it's any public law grounds. There's no dispute between us, and equally at paragraph 71 a number of important points are made, and that includes that it's different. The passage beginning fourthly in paragraph 71, fourthly, SIAC can consider whether the Secretary of State has acted in breach of any other legal principles applicable to his decision, such as the obligation arising in appropriate cases under Section 6 of the Human Rights Act. In carrying out those functions, SIAC may well have to consider relevant evidence. So, and again, that's no different in this context, that the tribunal will determine an argument about the ECHR for itself.
Yes.
The only other point to make is in paragraph 124 of Begum. About half the way down, it's an important point that the question how a policy applies to the fact of a particular case is generally treated as a matter for the authority. Now that's the point I made yesterday, which is that this case is a classic case of the Secretary of State making an evaluative assessment when she is determining whether she was satisfied that the citizenship was obtained by fraud.
Hold on, which passage are you looking at?
124, which is dealing with the policy.
Yeah, sorry, let's just find that. This is all dealing with preliminary issue 1, I think, which is all about whether or not the Secretary of State had complied with the extraterritorial human rights act policy. So I'm not sure to what extent this helps the argument, because on any view, if you're asking whether a decision maker has complied with his or her policy, that's a public law question.
Yes, the reason I make the point is that it's generally treated as a matter for authority. It's in effect an evaluative exercise which can generally only be challenged on Wednesbury grounds. The reason I make the point in this context is on the facts of this case, I say that the decision that was made about the condition in section 43 was an evaluative decision. So the Secretary of State, there wasn't, as there often won't be in these cases, any real question of fact, because the deception's been found out and the person has to hold their hands up to it. What the Secretary of State had to do in this case was to decide whether it had a material bearing on the grant of citizenship. Now, except there might be other cases where there is a factual issue, although not before this court in my submission, and not that I can think of in the authorities, because it usually is an argument about whether the fraud has had some kind of bearing. But in any event, on the facts of this case, I say that's clearly a case that the evidence that the appellant put in was plainly hopeless and irrelevant.
Well, that raises the question, which I think my Lord Justice Moylan had asked Mr. Southey, which is whether we should even get into this on this appeal. What do you say?
The court doesn't need to, because if the court dismisses the appeal has been dismissed.
That's certainly true.
And then it's going back to the upper tribunal. It's also fair to acknowledge that the issue will be reaching this court at some point, undoubtedly. But it's not necessary to determine this appeal. So in this particular appeal, it will be obiter, because the appeal, if the ground of appeal is dismissed, this is going back to the tribunal. It's going back to the first tier tribunal, and the first tier tribunal will be bound by cases like Chimmy, which tell it to apply Begum, and which deal quite specifically with post-decision evidence. Now, it won't matter in this case because there isn't really an issue about evidence here.
Can I just ask you also to deal with paragraph 78?
Yes.
Which is where Lord Reid specifically turned to another authority which will also bind the first tier tribunal, which was Lord Wilson's judgment, and the concession that was then made on behalf of the Secretary of State that it was for the tribunal to decide whether the ground existed.
Statelessness.
Yes.
Yes.
But the same wording applies.
Yes. Well, that's probably a convenient point then, and I can take that point first and just draw the strands together, and to say why we say that an appeal in this current context is limited to public law principles. So I'll come on to that point. Straightforwardly, the court will appreciate that my submission is that because that's what Begum decides, because there are two discrete questions, what the legislation says and the nature of the decision, and in this case the question is whether the Secretary of State is satisfied that the citizenship has been obtained by fraud. So that is exactly the same. The statutory language is the same. It's true that the precondition is different, but that can't drive the answer to the question of what the legislation says, in that it includes the words "is satisfied that." And the second point we make in relation to why Begum applies is that the source of the appeal right in a conduciveness case and in a fraud case is the same. And I've already made the point that the reason that it's certified into SIAC is not so that SIAC can look at the matter on a different basis because it needs to defer to the executive, but simply so that the information can be kept secret. So our primary point is that because the legislation says if the Secretary of State is satisfied that, it's the question for the tribunal does not become, is the tribunal satisfied that? And absolutely on that point, we say Begum is binding. So that was my first point. Can I then deal with the statelessness point, which is that Section 44 also says satisfied that, but the court decides the statelessness issue for itself. Well, one needs to be quite careful about this because we say statelessness is sui generis. we accept that the court decides the statelessness issue on evidence, and the authority for that is Al-Jeddah at paragraph 30, and that records the common ground to that effect.
But if it's common ground, does it bind anyone?
As I understand it, the same conclusion is reached in FAM. In any event, it's not something that I challenge, and it's not something it's important I don't get into that question for present purposes, other than to contrast, because there are issues.
Yes, but I mean, it seems a bit curious, doesn't it, that statelessness is sui generis.
Well, can I explain why we say it isn't curious? In fact, when one looks at it, because we say this can't be compared with the situation here. So the starting point is that the issue on statelessness is whether the person is de jure stateless, and that's determined at the date of the decision. It's not determined at the date of the appeal, and that the authority for that is Al-Jeddah at paragraph 32. So already one can see it's not what might normally expect in the appeal context, but importantly at 2 points. The first point, as we've seen in the history in Al-Jeddah, is that section 44 derives from international obligations, although Al-Jeddah says the Secretary of State went a bit further. So the Secretary of State has an international obligation implemented through section 44 to consider the statelessness question. But secondly, and we say this is really important, statelessness is a question of law. Now, albeit by virtue of a quirk in our domestic system, because it's a question of foreign law, it's a question of fact, which is proved to the satisfaction of the court or tribunal, and it's generally proved by expert evidence. Now, for a discussion of that, I won't ask the court to turn up now, but that question about evidence and statelessness is discussed in KV at tab 19, paragraphs 31 to 36, but it's paradigmatically, we would say, a question of law. So, if a question about foreign law were to arise in judicial review proceedings, similarly, the parties would likely be saying, well, the court has to consider expert evidence, look at the evidence, and decide this question of foreign law for itself. So we say, given that section 44 is fundamentally about law, that's an issue which is particularly apt for a court to determine, and bearing in mind that it's an international obligation not to deprive somebody if they are stateless. So we say that is sui generis, and what that can't do is prescribe the approach to section 43, which is a different question. It also has to be borne in mind that section 44 is an exception to section 42, whereas section 43 stands on its own. So we say that nothing in the statelessness context assists in relation to the present question, and we also say that whatever the position in that very specialised context, it isn't capable of unpicking what we say is the clear reasoning of Lord Reid in relation to the words the Secretary of State is satisfied that, and the fact that both rights of appeal come from the same provision, albeit that one may go into SIAC.
But in order to support your submissions as to 43, you place very significant weight on the word satisfied that. For purposes of your submissions as to 44, you glide over those. They're the same words, satisfied that.
I don't glide over them. In fact, what I say, I've addressed them head on, but what I say is, if actually as it appears in a judicial review, the position would be the same if there were a question of foreign law, the court would consider evidence. Well, because it's a question of law, but it's treated... I
don't think it is a question of law, it's a question of fact as to what the law is. That's an issue of fact.
Yes.
It's not an issue of law.
But
it's whether a person would make so it's the same, the Secretary of State, if he is satisfied that the order would make a person stateless. It's an issue of fact as to whether someone's stateless. The Secretary of State has to be satisfied of that. So it's the same structure as 42 and 43 and 44.
Yes, it is a question of fact. That is a matter of domestic law. It won't be the same in other states which are signed up to the convention, which is introduced the obligation to deal with statelessness, and it's right. The state of the applicable foreign law is a legal question, but the existence of the provisions is a question of legal fact. And then in domestic law, the judge's role is to determine the existence and application of the foreign law as a question of fact based on expert evidence. But we come back to the fact that one starts that it really is a question of law. When the convention says you can't make this person stateless, primarily that involves looking at other states' law. It may be a question of fact in this jurisdiction, but if one takes it back to the other point to make, and this is going to be, I've taken my submissions out of order because the important point to make when I say statelessness is sui generis, one also has to look at the authorities in the immigration context which deal with the question of precedent fact and the circumstances in which the court can decide for itself an issue about dishonesty. That's what the cases are about. So when one is looking at sorry, and just to answer, I'm still answering my lord's question in terms of statelessness. If it's right that the matter is decided on evidence, but the position is the same in judicial review proceedings, then there's nothing surprising about the outcome in a statelessness case, because my submission is simply that the tribunal or the court has to determine the fraud question by application of public law principles. If it's right that in a judicial review a question of foreign law would be dealt with by evidence, then the approach under section 44 is not different from the approach which might apply in the public law context. So I do say one can't simply say, oh well, that's it. The fact that that's what those words are construed to mean in that specialised context does not, in my submission, undermine what Lord Reid says. And I can't. I don't want to keep repeating the same submission, but that's our fundamental point, that one comes back to the statutory.
But are you suggesting that on an application for judicial review, if they're a question of foreign law, the experts on foreign law would be called and cross-examined?
No, that's fair. They wouldn't be called and cross-examined. There would be expert evidence. I suppose it's not out of the question that somebody could make an application for them to be called and cross-examined, but that would be unusual in judicial review. I accept that.
Because generally in judicial review, reliance on expert evidence that wasn't before the decision maker is deprecated. Was
yes.
That decision Lord Chancellor, I can't remember what was the exact name.
Yes,
Lord
that's
Chancellor
right.
was involved.
It is, but this is an unusual looking for. This is an area, and it in KV. What KV says is sometimes you won't need expert evidence. You can't just pull things off Wikipedia, but there are public sources of information. You can pull things off Wikipedia, I'm being told by Mr. So it's fair to say the court wasn't super impressed with things from Wikipedia in KB, but it says it's not always a matter for expert evidence. So I accept that the analogy is not complete, but I do say that the position on statelessness can't drive the position in a fraud case.
No, but it's curious, isn't it? Because the provisions are all closely contiguous.
Yes, but then we would submit it's curious if one goes the other way and says, well, okay, that's the position on the deprivation appeal on conduciveness grounds, but on fraud grounds.
Well, I've already put a point to you about that. Yeah.
Yes.
Okay.
So could I then deal? And this has taken me much longer than I
Well,
thought.
We've asked you a lot of questions.
Yes, no, I'm very grateful. I apologise, but yes.
No need to.
So, coming back then, still part of my drawing the strands together, is the position any different simply because section 42 involves a question of fact? And the answer to that is no, because the fact that there may be a yes or no answer to a question does not mean that the court decides that issue for itself. The starting point is that the starting point is coming back to the summary of Pisada. While I'm on Pisada, my junior has very helpfully looked again at that authority, and what we say about the facts of Pisada is that it was odd because apparently the decision was unclear as to even whether it was made under section 42 or section 43, so it was rather an odd case, and it's in that context that the first tier's tribunal's comments have to be viewed. But in any event, I say perhaps... And
also the first tier tribunal allowed the appeal on the grounds that the decision hadn't been made in accordance with law.
Yes. So it probably, on reflection, would have been more helpful if I'd just taken the court to the passage in Lord Reed's judgment, where he simply captures the head note. It's an odd case on its fact, but from my perspective, the important thing is that he says in terms, not just the discretion, but the statutory precondition, and then that does mirror the part of his reasoning that I rely on in, I think it was paragraph 66 or 67.
Can I just ask you one last final question about the extent of your submission on 42, 43, etc.? Suppose the Secretary of State gets information that a doctor is working without qualifications, and all the material that the Secretary of State then has from the BMA, GMC, etc., suggests the doctor doesn't have qualifications. Are you saying, and the Secretary of State is therefore satisfied, and it's perfectly reasonable to be satisfied on that basis, the doctor then comes or says, well, you've now taken my citizenship away because you thought I wasn't a doctor. Here's what I've got from Germany. Here's all the authorities. Is it seriously suggested that couldn't be reviewed by a tribunal?
One has to be careful because, of course, that in practice, the Secretary of State would call for representations in a fraud case. Different in the conduciveness context, and there's ongoing argument about that in the tribunals. But here, the Secretary of State...
I understand that, and it is just to test the point. But we all know that sometimes people miss letters on representations and Secretary of State reasonably takes a decision, or they haven't yet got the information from Germany because there are difficulties with data protection there, etc.
Yes. Well, then, suppose the matter comes to a tribunal, the person might say, well, I told you I was trying to get information from Germany, you didn't wait. That's an unfair decision, and therefore post-decision...
Well, not if it was reasonable to decide, well, I've got to make a decision.
And then if the person produces a piece of paper, then the Secretary of State has a power to revoke a deprivation order.
But suppose the Secretary of State doesn't, because there are lots of other perverse factors around which are not the justiciable reason.
Well,
You're saying the tribunal, even though it's an appellate jurisdiction, wouldn't have the right to hear evidence on it?
One would have to be... It is fact sensitive because there are issues in judicial review where there are circumstances where post-decision evidence is admissible. One of the examples is where, in a Tameside case, where it's argued that the Secretary of State failed in the duty. Another example is where there's been a failure to follow proper procedure. The question would be a question of fact. Was the Secretary of State entitled to be satisfied? Now, if the person says, well, hold on a minute, I told you I was trying to get this material and you didn't wait, then the post-decision evidence would be admissible. If for some reason, but in my submission, if it's simply a question of timing, if one examines your Lordship's question, because the question is, well, in your Lordship's example, the evidence has come to light by the time of the first-tier tribunal, but if it's a question of delay, it might not have come to light by the date of the first-tier tribunal. And then the question would be, does it satisfy the Ladd and Marshall test? So it is, in my submission, a question of timing to that extent, because, and the fact remains that if somebody says to the Secretary of State, look, here's this piece of compelling evidence that shows that I didn't lie, and the Secretary of State says, I don't care, I'm not looking at that she would be in the administrative court being judicially reviewed. So one has to be careful in my submission, and I of course appreciate why your Lordship asked the question, but it's a question of timing. There is an opportunity to make representations. If for some reason that material isn't available, there's a question as to whether the Secretary of State has conducted herself in a lawful way by going ahead with making a decision. I mean, one would expect the doctor to say, well, I am a doctor and I'll get the information from Germany. So all of those factors, but in a different example, where the person says I'm registered in Timbuktu and it's going to take 5 years to get that information, then that may be different. But in those circumstances, the tribunal wouldn't have it either.
Thank you.
So could I then? The court has Kawaja, and I won't take time on Kawaja now because we are short of time. But Kawaja is almost the mothership for precedent fact. It's at tab 55, and I'm sure the court has heard of it.
And read it, but not recently.
And read it, but could I just, I won't take the court to it now given the shortness of time, but could I just highlight some key factors? I will take the court to Giri because it considers Kawaja. But Kawaja at tab 55, the question in Kawaja was whether the person's concerned for illegal entrance. And the best judgment to read to understand the issues is a judgment of Lord Bridge, because he actually sets out Lord Scarman. Lord Scarman and Lord Bridge between them set out what the legislative provisions actually were. But effectively, what the House of Lords says, in fact, could I just give the court the paragraph numbers given the shortness of time, or there aren't paragraphs. Given the shortness of time, could I give the court the page references in the bundle? So 1378 at D to F, which is in the decision of Lord Fraser, explaining that was a precedent fact situation. Lord Scarman at 1387 of the bundle at C to D, 1389 of the bundle still in Lord Scarman at B to E, and 1389 at G to H. And then over the page, still in Lord Scarman, 1390 at D to G. And then Lord Scarman, 1392 at E to F. And then Lord Bridge, page 1396 at B to H. And I can email these over if that would assist. Would that be better?
What, the references?
The passages.
Yeah.
I haven't got many more now. I've embarked on.
You haven't got any more.
I haven't got many more.
Many more.
So,
Well, I mean, I've got a note.
1400 H, 1401 A to G, and then 1403 at B to E. In a nutshell, what the court says is there's a question of precedent fact there, because if the Secretary of State was entitled to decide that question for him or herself rather than the court, then the legislation should say so. And the relevant legislation essentially said where an illegal entrant is not given leave to enter or remain, an immigration officer may give directions. A person in respect of directions, whom directions may be given, may be detained. And essentially what the court did was overturn a previous authority where words were implied into the legislation that it was reasonable for the Secretary of State to consider or similar. Of course, what I say about Kawaja is the court repeatedly emphasises what the legislation says, and we come back to my submission about it is satisfied that.
Yeah.
But could I take the court to Giri then, which is in tab 13. So starting with the head note, tab 13, page 408. The claimant, a Nepalese national, applied for leave to remain, and exercising her power under Section 3.1 of the Immigration Act, the Secretary of State refused the application on the ground that the claimant's application form failed to disclose a material fact within paragraph 3221A, namely that he'd used deception in an earlier application for entry clearance, and at first instance Mr Justice J decided that this was a precedent fact situation and the Secretary of State appealed. In fact, sorry, the Secretary of State raised this point by respondent's notice. It was not the Secretary of State's appeal. So the relevant provision at issue is at paragraph 2 of the judgment, on page 410. It was a provision in the immigration rules which said that grounds on which leave to remain is to be refused where false representations have been made or false documents or information have been submitted, or material facts have not been disclosed. That was a ground on which leave to remain was to be refused. So the Secretary of State decided that that provision was satisfied in this case. For the court's note, no need to read it now, the legislative context is at paragraphs 9 to 11. And I should also draw the court's attention to paragraph 13, because a concession was made by the Secretary of State in relation to section 10, which is referred to at paragraph 13, and I'll draw the court's attention to that passage in a moment. So there's then an extensive consideration of Kawaja at paragraphs 18 and 19. Could I just invite the court to read paragraphs 18 to 20 now?
Yes.
And then paragraphs 24 to 25, that addresses a submission that was made in reliance on A, which was a case that my lady raised yesterday, mentioned in argument. And the court distinguishes A, and then crucial passage at 25C to E. I do not accept that Baroness Hale was intending to lay down any general proposition that because a question is an objective one, to which there is a right or wrong answer, it is necessarily one of jurisdictional fact of the court. These were simply considerations that form part of the reasoning in support of her conclusion as to the correct construction of section 20 of the 1981 Act. And then there's discussion of further authorities, and then the conclusion at paragraph 30, the judge's inclination to treat the question as one of precedent fact was wrong, and that he ought to have applied Wednesbury principles to determine the lawfulness of the decision under challenge. By proceeding to ask himself whether on the evidence before the court the Secretary of State had proved that deception had been used, he was addressing the wrong question. Now, we come back to so the ultimate conclusion is that because the Secretary of State is exercising a discretion here under the rules, the fact that she reaches a conclusion of fact before she exercises that discretion does not mean it's a question of precedent fact. And the crucial difference in my submission between what the Secretary of State conceded in that case about the power of removal, for example, is that the words the Secretary of State is satisfied that or similar do not appear. And that, in my submission, is the crucial difference, because the statutory test, the Secretary of State is satisfied that, the court, on the tribunal on appeal, approaches it in the same way as in Geary. Now,
Yes.
Although Geary was an application for judicial review.
it was, but it's simply my point that because there is a right or wrong answer, doesn't mean it has to be determined by the court. I accept that it's not the same as the scope of the right of
No.
appeal.
All right. So because right or wrong answer not follow.
Yes,
It's for
that's
the
it.
court. Okay.
And then two final points. That we make a point in the skeleton that our approach harmonises with the statutory regime for consideration of good character, and this case rather illustrates the point, because had this appellant told the truth, he would have challenged that refusal by way of judicial review, and it's no answer to say that, well, this is different because we're taking something away. It's not the reason that we're having to take it away is because of his deception. So to decide that the right of appeal is confined to public law grounds is to harmonise with the statutory regime for determining good character applications. The final point is one I trailed earlier, which is that there are discrete issues of, on the one hand, jurisdiction, which is decided by the statutory provisions and the nature of the decision, and on the other hand, institutional competence and deference. But I do say this case illustrates the need for this case illustrates that the Secretary of State is institutionally competent to decide these questions, and also in a deference type sense, but because it is the Secretary of State who decides citizenship applications, and therefore the Secretary of State who is best placed to decide whether citizenship has been obtained by fraud. So those were my. I heard the start of a question.
No, sorry, I didn't think I said anything.
Oh, perhaps I've become sensitive to questions. I was
You've been traumatised.
Yes, always. I was making a point about evidence, and I think I made most of my points in response to a question from my Lord Justice Dingemans. But can I just draw together the points about evidence? First, we say that, I do like a tail wagging dog analogy, we say that the question of, well, what about on these facts, would the tribunal consider this evidence, can't affect the primary question, which is what is the scope of the jurisdiction. The second point is one I made in answer to my Lord, which is there's an opportunity to make representations in the fraud context, so it's a question of timing, because if there's a question of late evidence, that doesn't disappear simply because there's an appeal. The third point I've made, which is that there are circumstances in which post-decision evidence may be admissible in judicial review. I gave some examples. The fourth is that human rights issues, the court decides on evidence. And finally, I made the point that if there really is significant evidence, then the person can ask the Secretary of State to revoke the deprivation order. Your Lordships and your Ladyship were handed the case of Harrison, and Mr. Southey made reference to paragraph 32. Could I in fact draw your attention to paragraph 31? Because that, in my submission, supports my submissions. it's not. I don't suggest it's a major point, but Mr. Southey stood up yesterday to raise it, and we say, indeed, that's why it's different in the citizenship context. That's why the court decides the question for itself, even on judicial review. And the passage in paragraph 31 makes an important distinction between a legal fact on the one hand and on the other hand where the Secretary of State is satisfied that. So to conclude this part of my submissions, I won't take the tribunal to the authorities, but I will give your lordships and your ladyship the passages to authorities to mention Mus Lea, which is in tab 29. That has very similar facts to this case. See paragraph 52, and that's paragraphs 53 to 55. The conclusion. That's a case where the tribunal applied a public law approach, and then Chimmy, which is a detailed consideration by the new president, is at tab 34, and I would invite the court to read that in due course. It's a consideration of the fraud exemption and the statutory jurisdiction, sorry, not the fraud exemption, the fraud provision and the statutory jurisdiction for the tribunal. In relation to questions about evidence, the relevant passage is at paragraphs 61 to 68. There are also passages sidelined in Chimmy. And in addition, could I just draw the court's attention to paragraph 89? When the court reads that, the court will see that there's a discussion about the Secretary of State having made what's described as a concession, or could be a concession about evidence. My instructions are that the point that the Secretary of State was making in Chimmy was that public law principles apply, but evidence can still be admissible even if public law principles apply. For example, where the argument is that an unfair procedure has been followed, but the President does turn his mind to evidence.
What paragraph is that? The concession?
It's not. It wasn't a concession, but it's.
I appreciate that, but you said it was phrased
Yes,
as a concession.
Paragraph 89, did you say?
No, it's between paragraph 61 to 68, but give me a moment and I will take the court to the exact passage. I had planned to take the court directly to this, so. So the conclusions begin at paragraph 48. The discussion of evidence specifically begins at paragraph 61.
Yes.
And the part that I was talking about is discussion of something that the Home Office presenting officer said at paragraph 64.
Okay.
Yes, it says we've described this as an observation and we don't think it appropriate to describe in any other terms it was not a concession.
Okay.
Had it been, we would have been minded not to accept it. But I asked about that, and I understand that the discussion was in fact about circumstances in which evidence might be admissible. Now, one thing I would submit is that there have now been a number of cases in the upper tribunal applying the Begum approach, and in my submission, none of them have shown that there is any particular difficulty with applying what Lord Reed says in Begum in the fraud context. And certainly in this case, in my submission, it's absolutely, it worked perfectly. The Secretary of State made an evaluative assessment of whether or not the citizenship had been attained by fraud. She declined to exercise her discretion she exercised her discretion to deprive of citizenship, and that is properly to be tested by public law principles, but even on a straightforward pre-Begum approach, the appeal fails for the reasons I've submitted. Two mop-up points, if I may. The first is that it's wrong to suggest that somehow we are arguing against KV, in the sense that KV proceeded on the basis of agreement between the parties, which essentially followed the approach in the upper tribunal. There is not a detailed consideration in that judgment.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Queen's Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
They will repeat it.
Yeah. How long do you think this will take?
Attention please.
We'll wait.
Attention please. This is the Incident Control Officer. An evacuation is in progress in the Queen's Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
So, yes.
Yes.
Yes, 30 seconds. So KV does not consider this. It effectively, the parties, although if Lord Justice Underhill, I think, says that he agrees, it's the parties have conceded it based on the upper tribunal authorities, and that was the accepted approach prior to Begum. And
Just on the point of upper tribunal, sorry to interrupt, upper tribunal authorities, case we're considering tomorrow, Ahmed, I think the upper tribunal did have some observations to make about the difficulty of applying the Begum approach.
it may, yes, I've put that case out of my mind.
Yes,
so I will be putting
but I
it
think
back in my
I
mind.
think it did. But anyway, don't
Yes.
worry. I mean, it's just an observation.
Yes,
passing.
I yes, noted. Just then, for completeness, Matusha, when we were discussing Matusha, 2 points arose. One, whether Chapter 53 was the same at the material time in this case as it was in Matusha. Yes, it was. And second, were we right to say that the guidance on good character in Matusha was the guidance that appears in the authorities bundle? But tomorrow's case, yes, we were.
KV wasn't referred to in Begum, was it?
Sorry.
KV was not referred to in Begum.
I don't think it was.
No, I checked that, and it's not listed at the beginning of the appeal cases.
It's perhaps not surprising because there wasn't any substantive.
No, I mean it's not directly in point.
Right. Okay. No questions? Well, it's 1 o'clock.
Yeah.
Well, I was going to stop now. So I was going to stop now on the assumption you were going to be more than 5 minutes.
I think that's probably a reasonable assumption, yes.
How much more than 5 minutes?
I was thinking probably 30 to 45 minutes.
Okay.
Can I also just say, while we've been in court this morning, we've been given the submissions yesterday, we've been trying to get hold of it. We have now got hold of it. We've got hold of the form that was submitted for the ILR. In the questionnaire that was requested is perhaps more accurate. I'm going to give that to my learning friend. So
Okay.
I, in one sense, it's probably sensible she doesn't formally end her submissions just in case there's something she wants to say about it.
Thank you very much. So 2 o'clock.
Well, it doesn't say very much, certainly, about previous statements or anything.
Just to make that clear, that was before the FTT.
Yes,
Yeah.
I think I've seen.